Yes. Hello, my beautiful friends. What an amazing day it is. A tremendous live stream planned this evening. We've got some serious fallout from the Supreme Court victory that we saw breaking yesterday during the show. We now have a big battle that is brewing between Judge Indira Talwani and the DOJ. We saw that the Supreme Court had already said that there was no standing for the states to even file their lawsuits challenging the Trump election executive order. But Indira, the Obama judge, doesn't care. She says, well, I'm going to still hold you in violation of my prior order. And we've got a back and forth between the two of them. And so things are getting spicy out there. We're going to break it all down and take a look at some other reaction to what happened yesterday, including what Americans think about election integrity. Then we've got some big updates out of Michigan. We saw before that there was a sheriff named Dar Leaf who explained that there had been somebody who came to him and said that there was enough evidence of criminality to justify a criminal referral from the sheriff over to the DOJ. Well, now we have even more town clerks popping up out of Michigan explaining that it is worse than we even think. And we've been covering this lawsuit where Jocelyn, Benson, the Secretary of State, ordered election records to be deleted within 7 days. And so that lawsuit now is a response from Jocelyn, and we've got a response to her. And so the battle continues out there in Michigan, where Jocelyn is leading the election fraud. And then lastly, a big win out of Georgia on a redistricting issue. There were new maps that were drawn after 2020. And the Democrats were furious about it. They said this new map is racist, and so a lower level judge blocked it. But we have an appeal that is delivering the goods. And so we're excited to get into all of it with you. And we're very glad that you're here. Thank you for subscribing to the Watching the Watchers fam. And it looks like everything has connected itself, which is tremendous news. That means we can go ahead and get started. So let's do it, shall we? Because we've got a bunch that is brewing out there, starting right now. Major fallout from the Supreme Court victory. We saw that SCOTUS slapped down some lower judges and said, you shouldn't have even been hearing these cases. When the blue states sued the Trump administration over the new election executive order, lower courts were blocking everything. Every which way we turned, we had the citizenship list being blocked. We had the Postal Service regs being blocked. And the problem with all these judges is that we're entertaining plaintiffs who had no right even to be in court at all. And the Supreme Court came down in a per curiam decision and said 6-3, you guys lose. The blue states are complaining about harms that haven't even happened yet. And now we have a major back and forth. So as soon as Trump got wind of the Supreme Court decision, the DOJ went wild and started filing a bunch of documents in other cases. The case that the Supreme Court ruled on is this one right here. That is State of California versus Trump, and they just got slapped down big time on this one. And the judge here is Indira Talwani. Now, you may remember that name because we've talked a lot about her. She was appointed by Barack, and she also got another election case, very conveniently, which was the League of Women Voters versus, again, Trump. Both of these were filed in Massachusetts, one of the most rigged jurisdictions everywhere. And she also blocked the executive order in this case as well. Now, you'll notice that there's a big difference here. Of course, Trump is the defendant in both cases, but one was the blue states, California, and a bunch of the blues. This one was the League of Women Voters. And as we contemplated yesterday, as we were reading through the actual decision from SCOTUS, if the blue states don't have standing, they're the ones who actually run the elections, arguably. And they were making their best case to say why this order harmed them. The Supreme Court just said, it doesn't. You guys are whining about nothing. You have no standing, and so get out of here. Now, we got the League of Women Voters, who I would argue have even less standing than the states do, because this is just a nonprofit that is largely educating their members. They have to write manuals and update their websites, and they say that they're in a state of confusion. It's very difficult to change election rules. They're not going to know what to do because they're so dumb. But now the judge is firing back in this case, but not before the Trump administration and the DOJ just went wild. And we had a bunch of great filings that dropped last night and today. Let's not forget who the judge is. Indira Talwani, appointed by Barack Obama back in 2014. And she's a tried and true liberal, was a person who worked in civil litigation. And of course, we know that the ascension model for the leftist judges is to work in Democrat law firms and then they get promoted up to the top and serve their Democrat masters, not the Constitution, as they would have you believe. But she's the one who's presiding over both of these cases. She just got slapped down literally by the Supreme Court, and now she's going wild in this case. But the DOJ unleashed, and they came at her pretty strong here. They said, all right, Judge, as soon as SCOTUS handed this down, they then submitted an emergency motion from the DOJ. They said, Judge, you're wrong. We told you were wrong. You issued an injunction. You're blocking our executive order from the president. All that this order does is tighten up some of the election procedures ever so slightly, and they're so mad about it. And the Supreme Court was very clear. This is an inter-branch decision. This is the president changing how the governance happens inside the executive branch. There's nothing going on. No one's commandeering anything at the state level. They still can run their elections. They don't have to use the citizenship list. They don't have to use the Postal Service list. And even the Postal Service rule is not going to refuse to collect any ballots. They're going to pick them up anyways. The only real significant change was a barcode. They're going to be able to track the election mail so that they can identify if they're getting an overly, I would say, large amount, a gigantic amount from one area. They're picking and tracking up. Do we have gobs coming from this zip code and we shouldn't? Do we have gobs going to that zip code and we shouldn't? So they can corroborate the numbers, and they're very mad about that. So the DOJ, soon as SCOTUS issued their order, went after the judge. They said, all right, hey, Talwani, we're back in house now. And we now want you to immediately consider and vacate your primary preliminary order, the one that you already dumped on us, because we have intervening and directly controlling authority from the Supreme Court of these United States. That's your boss. You don't have discretion to just decide we're not going to follow it. So as explained below, and they're referencing the Trump versus California case, she knows what it is because it was her case. So as explained below, the Supreme Court leaves no room for any further dispute, okay? You, this court, Judge Talwani, you lacked jurisdiction to issue your preliminary injunction in this case, just like you lacked jurisdiction to enter summary judgment in the California case, because there is no justiciability, there is no controversy over a proposed rule. So if you're not going to reverse yourself, we want at least to stay pending further appeal of the order, which they're doing now. So to further avoid any irreparable harm, the Supreme Court did the balancing test and said, actually, the block of the executive order is harming the government. They're now parlaying that into this argument, saying we're being harmed now. If you want to stop this, we ask and respectfully request a ruling on this motion by 5:30 p.m. today. And so, to be clear, the Supreme Court's order makes clear that a jurisdictionally void injunction, your block, had no basis in the law. You did not even have jurisdiction over the case because the people who sued shouldn't have even been here. It interferes with the Postal Service, and it imposes a serious irreparable harm upon us. And the Supreme Court has repeatedly instructed you and other district courts to follow their orders, which applies to this matter right now. So absent relief by that time, we now, the Solicitor General, has authorized the filing of a motion to stay up to the Court of Appeals. If you don't stop your block right now, we're going up. So they clarified. Earlier today, the Supreme Court granted our motion for a stay in the companion case, Trump versus California, also under Indira. And as this court is aware, since it's your case, that case is consolidated with this one. Why? Substantially overlapping issues. Now, in that case, just like this one, the government, the DOJ, are arguing that the plaintiff's lawsuit, just like the blue states, just like the League of Women Voters, all were premature and both should be dismissed on standing and ripeness grounds. And the Supreme Court accepted those arguments, said we win, said the blue states have no basis for being here. We had a 10-page per curiam opinion. We read through the whole thing here, and it was a glorious day indeed. Now, as SCOTUS already explained, in case you didn't read it, Section 3 orders an initiation of a process, and they're proposing a rule. And it's not a final rule. So we're allowed to contemplate these things. We're allowed to think about it. We're allowed to write things down, have meetings about it. Once it becomes an actual final rule, and when you can articulate a specific harm, then you can sue. Supreme Court also said, we deserve a stay. We read through the whole order yesterday, so we don't need to rehash it. but they're just reminding this judge, we just beat the heck out of you. So they also go on, you can't continue this. This is a textbook case for reconsideration. Whether conceived as an intervening change of law or whatever, SCOTUS handed this down. The Supreme Court has squarely held that a lower court, that's you, errs when it refuses to modify an injunction when there's a significant intervening Supreme Court decision, and that just happened. And so in California, the Supreme Court squarely held that federal courts review final rules, not proposed rules, and you can't just shove yourself in here to take over our litigation. So that holding applies with full force right here because it also applies without regard to the plaintiffs or who they are. You can be the blue states, you can be the League of Women Voters, doesn't matter. This bars an injunction in this case. And the conflict here with California goes even deeper still, just lacing into her. The Supreme Court's disagreement with this court's first injunction was based on an attenuated chain of inferences. And they articulated that very clearly in the SCOTUS decision. She says, well, it could be a problem if this happens. And then if this happens, then this could happen. And then maybe if both of those things happen, then this could happen. The court articulated 5 layers of different inferences that they would have to stack on top of one another in order to reach a harm that would legitimize their lawsuit. And you can't find speculative and hypothetical harm. So to the extent that there are differences between California and the League of Women Voters, as we said yesterday, their theory here is even weaker. Unlike in California, these are just members of some group. They haven't faced any direct regulatory burdens from anything. California arguably has an argument there, and the Supreme Court just said, you lose. So based on their prior filings, they may attempt to argue the Postal Service is unlawful and more. But the point is, Judge, anything that you have done is directly contrary to SCOTUS and to basic principles of jurisdiction. Whew! Man, she's dumb. Doesn't even understand basic principles of jurisdiction. Blown out. So because it is now clear that you lack jurisdiction to issue this injunction, it must be vacated immediately. Of course, if they want to challenge the final rules, then they can amend their complaint. What they can't do, though, is leverage a judicially, jurisdictionally void injunction. The whole thing is dead in the water right now. Thank you to SCOTUS. Now, if you're not going to do this, we ask for a stay and we want you to vacate your injunction. And so in short, DOJ is here saying we will continue to suffer irreparable harm from you, and the government is likely to win and is certain to succeed on the merits of this appeal because we already just beat you right next door in the other case. You probably have the file on your desk right now. You just lost that one. So now you're going to lose this one. So for these reasons, you, Indira, shall immediately or should immediately reconsider and vacate your injunction because you just lost in California. And if you don't, you should stay this, and we would like a decision by close of business today. So thank you very much. Your friend, Stephen M. Pezzi. And this is pretty aggressive. We love to see it because why wouldn't they be? They just won. So they also supplemented that. And then we get a response from the judge here coming up. But they say, we also, because what happened is the League of Women Voters, before SCOTUS handed down their decision, they came back out and they said, this is an emergency motion to enforce the judgment. So what happened is the Postal Service ultimately posted the rule. Okay, it's not final. They said, this is what we're doing. And in the new rule, they even wrote that we're not going to implement this because we're all being injuncted, but we're just contemplating it. We're going to take notice and comment. We're going to start gathering people's concerns. So it went online, and then they said, in response to the League of Women Voters, they asked for an emergency motion to enforce her injunction because they were arguing that the DOJ and the Trump admin was violating the order, even though SCOTUS just said she had no jurisdiction to even issue the injunction. So they also followed up with this. We'll hit the highlights. Saying on Friday, the Postal Service made available for public inspection a final rule for publication. And then immediately thereafter, we filed a notice with this court, and we told you that. As explained in the notice, based on the fact that you've injuncted us twice, Indira, one in California, which just got overruled essentially, and in this case, the League of Women Voters, we put in the rule. We're not going to take action on this rule for 2026 until we beat your injunctions. And the final rule will impose no new regulatory obligations at all, so therefore there will not be any harms, even if they're articulating these harms which are not even real. Because of those significant limitations on the legal effect of the rule, which were included solely to ensure compliance with your order, the publication here that we just put out, whether on the internet or formally in the register, it doesn't violate your injunction at all. She's going to disagree in a minute. Plaintiff's motion should thus be denied. You can't enforce something that you had no jurisdiction for. Now, that result is even clearer now that the Supreme Court has just granted us a victory in the companion case in California on jurisdictional grounds that are equally applicable here. We already explained that in the motion we just read. So now that SCOTUS, your boss, has made clear that this court never had jurisdiction, okay, the whole thing is invalid, to issue the injunction in the first place, respectfully, this court should not compound that error. You shouldn't double down on this by issuing further relief in order to enforce its prior jurisdictionally defective order. Instead, this court should grant our motion to reconsider, consider this one as moot, and hand us the victory that SCOTUS says is ours. They give us a little bit of background on all of these overlapping cases, and it is a little bit confusing because there's so much going on. The Democrats have a lawfare machine, and they just start pumping out the lawsuits and sausages from Mark Elias's. Anyways, so they explain background here. There was a League of Women Voters case, the one that we're on right now, saying after Trump issued the EO back on March 31st, then the League of Women, they all then filed the lawsuit, and they said, we're going to be harmed by election integrity. So the court granted in part their motion, denied our motion to dismiss, saying that they are going to win, even though turns out SCOTUS says they don't even have a right to be heard. So again, lots of filings that happen here went up to the Court of Appeals. Then we also had the California case. This is the one that SCOTUS just slapped down. Now, meanwhile, in a related case, then the blue states also sued. And so the court again granted in part their request, denied our request. Then we had a notice of appeal. Then we went to SCOTUS. Then SCOTUS actually gave us a victory yesterday. Bum-ba-da-bum. The Supreme Court granted a stay in California, reasoning that at the time the lawsuit was filed, which is where you measure standing, all of it was speculative. And so yesterday, after the Supreme Court issued their decision, these federal defendants, as we just read, then moved to actually reverse the injunction. And so the final rule, as we saw, was published 9 p.m. on Friday. And the judge was mad about this. She said, how can you publish something when court is closed? She was at home sipping a spritzer or something. And then this thing went online. She had a meltdown. Mark Elias and all the leftists lost their marbles. Now, within minutes of the final rule getting posted on the website, we filed a notice, let you know that it's going to happen. And if you actually read the rule, you can see inside we said we're not going to do anything with it until we beat your injunctions. Then the following day, the leftist lawyers and the League of Women, they filed what they said was an emergency motion to enforce all of this. Now we oppose it. And just to be clear, we were in total compliance with your order. We take orders very seriously. But respectfully, that is exactly why the final rule is phrased the way it is, if you couldn't even read. To comply with your orders, not to violate them. If they believe that the Postal Service new rule is unlawful and should be enjoined, the actual path forward is pretty straightforward. They should amend their complaint and challenge the rule directly, allowing the parties to brief the legality on the merits here for the first time ever. And if you conclude that the rule is unlawful, you can grant relief. But regardless of the outcome of that possible future litigation, the publication of a final rule that will currently be implemented only for elections after the midterms and will be implemented for 26, if and only if these injunctions are vacated, it can't violate your order because all we're doing is just contemplating these things and posting it on the internet. So in any event, now the Supreme Court has said we win. That provides an even more straightforward reason to deny all of this. The court should now vacate your injunction. We didn't violate it, but now we've won so overwhelmingly that you need to actually just undo what you've done. And why? Because SCOTUS said you acted in excess of this court's jurisdiction. Shouldn't have done it. So they continue on and they say, vacate this baby because the current procedure is analogous to other cases where you tried to enjoin us. The district courts are acting outside of their power And the same logic applies here, meaning you should vacate this. You can't issue something over which you have no jurisdiction. So even if this could somehow survive the Supreme Court, which it can't, there is no basis to grant their motion to enforce. We wrote in the rule that we are not enforcing this until the injunctions are reversed. And even this common sense understanding of this manifested itself in these proceedings. The court already appeared to acknowledge that this approach was permissible. You said we could do this on the record in open court at the most recent hearing. Here's what the discussion said. Judge Talwani said the following. Well, you sometimes have staggered rules. That's common. So you put out a proposed rulemaking, and then you say we're going to do this. Like, for example, we're going to put minimum wage in $10 an hour this year and then $14 an hour in 3 years, whatever. She's coming up with a hypothetical. So there was nothing to say. There was nothing to stop on this proposed rule to say we're putting this into place in January. And the issue of what's going into, and frankly, there's nothing to have stopped you from saying we would put this into effect as of this date if it's permitted by the courts, right? A conditional. We'll do it if it is approved. And so the government responded and it said, again, the Postal Service may very well come up with that type of rule. We simply don't know what the Postal Service, what their final rule will be because it was all being contemplated. So the judge even explains like a conditional is okay. So they did that. In other words, the court openly contemplated the possibility in light of now having been given limited relief from SCOTUS that we could publish a rule for which the legal effect in the upcoming elections was conditional upon whether or not it is permitted by the courts. That's literally exactly what we've done here. If it's permitted by the courts, we put it in the rule. But because that conditional presupposes the prior stay or reversal, that scenario is not a violation. We're literally putting it in there in order to comply with you, Judge. So if we don't get actual relief, it's not going to go into effect. And so it's an undeniable legal reality, which means their entire order and demand for an emergency enforcement should all be denied. So were there any doubt in this about the lack of conflict? Even their requested relief from the league, even their demands confirm it. They wanted the following: an order stating the final rule has no force or effect. Guess what? It doesn't have force or effect. We put it in there. They want an injunction and saying that they're directed that to not do anything that would change the status quo for any covered election. Great. It's in there. They put it in there. And an obligation to file compliance updates every week. We're doing that. So set aside the weekly compliance updates. We're literally doing what they're asking for in their demand for relief. And so the status quo has already been maintained. And of course, if we do get relief in this one, just like we did in California, then our rule can go into effect. And so ultimately, the fact that their relief would change nothing about the status quo confirms that we haven't violated anything. And if there were an actual violation, they would then presumably request an order that we must stop violating the injunction. And they haven't done that. Now, in any event, even if they had requested that relief, it would be improper. Although virtually every significant rule or regulation is published in this way in a staggered process, we're not aware of any prior precedent where a court issued an order preventing formal publication when we're already contemplating this. And the rule has already been published on the website. It's live. So any other arguments from them also lack merit. The motivation for posting this rule has nothing to do with the question of whether it complies with your order. The compliance question turns on the language of your order and the legal effect of the rule. We put it in there. It doesn't have legal effect. So most of their filing in the original motion ignores the critical language of the final rule. They don't want to actually reference it because it's damning to their case. But when they eventually do get around to responding to the most important feature of the rule, their response is that whether or not the U.S. Postal Service refrains from further action, an immediate effective rule is an effort to implement this order, and you can't do anything. They say that is wordplay. That's not even a legal argument. They already agree with us, and we agree with them that it won't be implemented. That's what they wanted. So even and eventually in their response, they are left to baselessly imply that the Postal Service is lying, saying that these assurances that it's not going to implement this is belied by the rule's texts. And they argue that There's a severe disagreement about this, and then finally assert that the final rule, this is what they're so confused about because, they're so dumb, it's going to sow widespread confusion, and no one's going to know what to do. All they have to do is put a barcode on the outside of the envelope. Not even complicated, but it is for them. So more importantly, the possible confusion that will or will not result from this has nothing to do with the question that is currently before the court. Did we violate the order? We did not. So they can amend their original lawsuit if they want to, but otherwise, their motion to enforce all of this should be denied. The court should order the parties to meet and confer, and they can amend their complaint to actually challenge the final rule because we haven't violated anything. Signed once again by Stephen M. Pezzi. Now, this judge, Indira Talwani from Obama, as we've just articulated, she's got no jurisdiction over this case. The Supreme Court just slapped her down in the companion case, saying that even the states don't have jurisdiction. So therefore, everything that she has done is void. They have no basis to even hear these plaintiffs in the League of Women Voters case. And also, let's not forget that the red states have been intervening in these matters to say, we actually want the order. We want to have a citizenship list. We want to have barcodes on the mail-in ballots so that we can actually track these things. So then Talwani issued this order today. And this, once again, is in the League of Women Voter cases. And the shamelessness of these people is really quite disgusting and something I say. So here she responds to the Trump DOJ's request, and she says, just so you know, the nationwide injunction entered in this case prohibited the government from, quote, implementing, giving effect to, or enforcing the order. Quoting herself. Now, Trump did not seek a stay of the injunction in this case and hasn't filed an appeal. But nonetheless, on Friday evening, August 21, the worst day ever, millions of liberals screaming into the sky like that meme, they posted it on the internet. They completed a rulemaking. They sent a final rule over to the Federal Register. And that final rule gives a nod to the ongoing litigation. She says, yeah, in the rule, it says, given the injunctions currently in place in these two cases, and by the way, the Supreme Court just said this is invalid, essentially. Okay, you can't have standing at the time that you sued in order to complain about these things. Now, the Postal Service, she references, will not take actions to implement any of this, but based on the language, they say from the Trump people that they're not violating the injunction because it's in the rules. Now, those arguments, writes the Obama judge, ignore the explicit directive of me. I'm the president now. And I said, do not initiate, do not complete the rulemaking. Okay, she is now stepping over into the executive branch and saying that they can't even initiate something. You can't even begin thinking about this rule because it's going to be so harmful, or complete it at all. And defendants cannot contend they misunderstood this. In fact, she says, and she slaps back at the Supreme Court, this is wild, saying that the defendants feigned complete compliance with California versus Trump, the state case, when they went up to SCOTUS. And there, they lamented the passing of every day that we couldn't actually do our jobs. We couldn't actually articulate policy out of the executive branch. And so accordingly, despite Trump's DOJ's protestations, the U.S. takes its obligations, they said very seriously, as we just read. The court finds the defendants violated the injunction. Wild. And she writes that the Supreme Court, in this footnote, accepted the government's feigned compliance. Like, SCOTUS is so dumb that they accepted the government's lies. This is how bad this is getting. Finding a likelihood of irreparable harm from this rulemaking. And so now the League of Women Voters, they want a remedy. And they want this to be ordered that it has no force in effect, and they can't even take preparatory steps that would change the status quo for a covered election. You can't even think about it. You can't even have a meeting. Defendants argue that these requests would confirm the current status quo. The final rule is up, but they can't implement it, saying it has no force in effect. They also say that the plaintiffs are not without remedy. All they need to do is go amend their complaint. Their original complaint was about something that didn't exist yet. Now the rule at least is published. So go amend your complaint. Now you have the final rule that's online. Go challenge that. She says the court understands from prior filings that the plaintiffs are not challenging the final rule, but they want the whole EO to be nuked. They claim the executive branch lacks authority to regulate elections. They're not regulating elections. SCOTUS just said that. The Supreme Court went through 6-3 Talwani and went through 3 different sections of the order. Nothing mandates the states do anything. There is no regulation at all. They're regulating the Postal Service. They're creating their own lists. None of it is mandatory for the states to engage with at all. And she says because the Postal Service is an integral part of the state's mail-in balloting, that the Postal Service cannot do anything there because authority with elections rests with Congress and the states and not with the president. And so the president can't actually govern one of his agencies because it implicates the elections and a tool that the states need to commit fraud. In other words, if the federal government wants to tamper down on fraud using the Postal Service to get it done, then what that means is they have no power and fraud can continue on. If it implicates elections, election fraud is perfectly acceptable, according to her. But defendants' violation of this order may ultimately inure to plaintiffs' benefit where now a final rule has been issued despite the pendency of the injunction. They could choose to file a new complaint, but nothing in the final rule and the issuance of the final rule is no longer hypothetical. And so therefore, for the foregoing reasons, the court finds that they violated the preliminary injunction, but imposes no other remedy other than identifying the violation. What? So they breached your court order, but you're not doing anything about it? No remedy other than identifying the violation. Man, she is something else, isn't she, Indira? So I think that kind of gives away the whole game. So she says, I think you violated my order. It reminds me of Judge Boasberg, but she can't really do anything about it because she knows the Supreme Court just said she doesn't even have jurisdiction over this case and they couldn't even sue based on their alleged harm at the outset of the lawsuit. So no remedy other than identifying the violation. Great job. So why'd you spill all that ink? Because you can't do anything because you know you have no jurisdiction over this. So what are you going to do? Order them to show cause. You're going to haul them in and start discovery proceedings. What are you going to do? Nothing. You know the Supreme Court slapped you down in the other case. So now you just want to mark it down. And really sounds like nothing's even going to come of it. So we'll see ultimately what happens here. But the DOJ now duking it out with Talwani, the Obama judge, who was appointed by Barack back in 2014. And yeah, very curious lady here. So this, once again, is more evidence of a judicial coup. She has no right to even hear this case. This case should be dismissed based on what SCOTUS did. And at least the injunction needs to be vacated and stayed pending the appeals, as SCOTUS said in the companion case in California. But she won't do that because judges are motivated by blocking the president. They want to stop any election reform at all because even adding barcodes to the envelopes would be devastating for their outcomes. So that is what the latest is. More fallout from this. We'll see what the DOJ says in response to this. If they appeal it, there's really no consequences. So I guess the rule can stay on the internet. And then she'll issue another order that responds to this prior filing that we saw here, which is to actually stay her injunction. So if the injunction is stayed and there's no penalty for violating the injunction and the order is already on the internet, then I guess it's going to go into effect. Is that where we're at? She is just throwing a temper tantrum. As far as I can tell, there's no consequences at all. So that's from Talwani, about what you would expect from her. And this is also going to spread to the other cases with Sparkle Suknanan from Trinidad and Tobago and more. We'll come back on that. But now we see the RNC is also fighting for proof of citizenship. We want that integrated into our election systems. We want a citizenship list, which Trump imposed via executive order. We want Postal Service authority to fix the chain of custody, to identify where ballots got delivered, where they got picked up, how they're being counted, and more. And here is a little bit of a summary on how the American people feel about this, courtesy of Fox News.
Well, verifying U.S. citizenship remains a very, very popular thing on a bipartisan basis, just verifying citizenship before you're able to vote. We got some Fox News polling just as of last month.
Wow.
I mean, across the board, overwhelmingly popular with Democrats, Republicans, and independents to check citizenship, not just with voting, but also with registering. But you look at those numbers and you look at how Democrats are reacting to this SCOTUS decision. California Governor Gavin Newsom saying in part, quote, California will be suing again to block these Orwellian rules from being implemented. Illinois Governor J.B. Pritzker, quote, deeply troubling. New York Governor Kathy Hochul, quote, New York challenged this unlawful executive order from the very beginning and will continue the fight. Carrie, what is Orwellian about this?
They're going to lose. Yeah, they don't want any checks and balances on the system because they exploit it. And they go and do the ballot harvesting. They exploit absentee ballots. They have entire sweatshops or whatever was going on in Michigan where they send people into strip malls and falsely register people and then add them to the polls and then pick up the ballots that are sent out. Signatures are not even being checked. They don't match. Nobody cares. You can register illegal aliens and then they suddenly find out when there's a glitch. It's Orwellian because for them, they can't win. It's oppressive to them. They need to control the entire system top to bottom.
It's so bizarre. I mean, they've gone from common sense things like voter ID, which, again, everyone understands why this is needed, to the even crazier proposition that we shouldn't be checking to see if someone's even a citizen before allowing them to vote. There's another Supreme Court case that's going to be heard this term dealing with Arizona attempting to do the same thing. Can you take non-citizens off of the voter rolls if you find out they are not actually eligible to vote? It's amazing we're even having this discussion. It shows just how radical the Democrats, pushed by these DSA extremists, have become.
Exactly right. Carrie Severino is a genius, so she knows what's going on. And Based Mike Lee is saying, you know, right now it's a battle between the president, the executive branch, and the judiciary. But we have another branch of government. Oh, yeah, almost forgot about them. It's called Congress, the legislative branch. Maybe they could help with some of this stuff. Here's Base Mike Lee saying, today's SCOTUS ruling was a huge victory for election security, and it was about standing largely slapping down the leftist lawfare organizations, the League of Women Voters, the Retired Alliance, and so on and so forth. The NAACP, the SPLC, they create all these groups and they sue. The civil ACLU, all of them. Now, as I explained in this clip, says Base Mike Lee, Congress still needs to pass the SAVE Act, Save America Act, now more than ever. And so, John Thune, we're calling you out there, buddy boy. Please reconvene the Senate immediately and announce that we'll debate that bill until it passes. We know the Senate is doing whatever they're doing right now, campaigning or whatever, not doing anything. And so Mike Lee says, get off your butts, come back to D.C. and get this done.
Congratulations to President Trump and his administration in securing a huge victory today for our election security in the Supreme Court. The Supreme Court today stayed a lower court injunction that would have prohibited President Trump's executive order issued in March, restricting the use of mail-in ballots, making sure that states would have to follow certain procedures to make sure that anyone voting by mail is in fact a U.S. citizen and that we know who they are. This is a big victory. Now, there are other pieces of litigation involving that and other executive orders. All this goes to the point that while this is a huge victory, and I applaud President Trump and his administration, especially his Department of Justice, for working overtime in trying to protect our election security, Congress has to do its part. This does not take the place of, it cannot replicate the Save America Act. We need the Save America Act, and we need it passed right now. John Thune, I'm calling on you and every other Senate Republican.
Let's go.
Let's reconvene the Senate right now, and let's pass the Save America Act. Sure, we don't have 60 votes, but, you know, we have a simple majority. And if we reconvene the Senate and announce we're going to debate the Save America Act until it passes, not going home, no recesses, no weekends until it passes, it would pass. It might pass with a couple of changes, but it would pass. Let's get this done now.
Let's do it, John Thune. Calling you out there, bucko. Don't know what you're doing, but you're definitely not working on the Save America Act, and we need you to do it. So this is another pattern that we're seeing where Congress is deferring to the executive branch. They don't want to jump in on any of these contentious issues. We've got people like Lisa Murkowski who say it's the rural voters. We can't actually have citizenship checks because they don't have the ability to go drive to a location to fill out the paperwork. It's the same argument that Kamala Harris made. So right now we've got a battle. We've got another obstinate, I would say, insurrectionist judge in Indira Talwani, who is once again flagrantly violating the Supreme Court, although she knows she's violating the Supreme Court. She says, you're in trouble. Okay, what's my penalty? Am I grounded? Are you taking away my PlayStation? What's the problem? No, I'm just noticing that you're in trouble. Okay, I guess there's no consequences at all for it. So now she's going to have to go back, take a look at the case here, the League of Women Voters, presumably follow the Supreme Court unless she wants to violate their orders and lift the stay on the prior case. Or maybe by the time we get there, they'll amend their complaint now that there is a proposed final rule. So all this is battling back and forth. The major win, I'd say here, is that she knows she's cooked, which is why she's not actually doing anything about it. So we'll continue to enjoy the SCOTUS victory and keep our eye on this litigation. But you can also sense in the DOJ's filings here that, respectfully, they're pretty tired of her crap. And they're now not mincing words anymore, saying, I want a decision by 5:30 today. And in fact, let's do a refresh to see if she complied. That's the California case. It is now past 5:30 Eastern time. And oh, what did she do? Fresh out of the oven. Yeah, that's what we just said. She's now granting their motion to file a supplemental complaint. So she's going to go back now and say, just revise your original complaint. And then they'll allege a bunch of harms in there. They'll say, now that this final rule is out, now we have these harms. And again, I don't think that that's going to be all that sufficient because the Supreme Court said, literally, the order from Trump said, follow the law. And all of it was interagency. Nothing was mandatory. Nothing was forcing the state's compliance. There is no overtaking of the elections at all. All they're doing is setting some standards for the Postal Service. How complicated is that? Well, for them, it's very complicated because it might result in their electoral obliviation, which is why they're so mad about it. So they'll go back, they'll file their complaint, and she'll probably try to stall this out to see if she can just kind of parlay that complaint, amend the complaint, then say, oh, the new complaint is also sufficient now for the injunction. And then we're going to have to appeal this back up to SCOTUS again or to the Court of Appeals. And so we'll see if this portion of the stay gets lifted. I'm going to guess she's going to try to race this through and then just incorporate them one after the other. But it is good. She's complying with the DOJ's request. They said, we want it by 5:30 today. So she issued a response by 5:30. Good judge. Continue to obey their demands. So we're going to keep our eye on this case. I think it's just warming up, and the Supreme Court has handed us a major tool that we can now leverage against these activist judges. We'll see if they comply. This has Judge Boasberg, Judge Jeb written all over it again. So we'll continue to monitor this election litigation and more. Thank you for joining and subscribing as we do. All right, lots more on elections here. Now we're turning over to Michigan. More town clerks in Michigan are acting as American heroes and speaking out against electoral fraud, all being orchestrated by Jocelyn Benson, one of the worst secretaries of state in America, who's now running for governor. This woman came out and is a follow-up to another town clerk, which is a follow-up to the sheriff, who now is making a criminal referral to the DOJ, saying that the Secretary of State's office is literally registering illegal aliens to vote. They change their address. There's other processes. They get on the rolls. The town clerks who are supposed to actually run the elections are saying, we can't remove them. When they go and complain to Jocelyn, she says, well, I'm going to give you the list. And once you get the list from my office, we register them all. We add them and add them and add them and add them. Then you get the list. You can remove them and validate that. Problem is, they can't. By the time the town clerks get the list, all of the appropriate columns in the spreadsheet are removed, like the important one that says citizenship status, all cut off So the clerks get lists that they actually cannot validate technically at all. So she has now emerged, and she said this on video, and this is a very brave thing to do. So shout out to our Michigan town clerks. More of these people are speaking out right now. Some of them are filing lawsuits, as we're going to take a look at here. Jocelyn is fighting back hard against them. And it's not just one crazy town clerk. We've now got multiples all putting their names behind the truth. Here's this woman from Township Hall out in Climax, Michigan. Nice.
Hello, my name is Sarah DeBoer. I'm the clerk of Climax Township in Kalamazoo County, Michigan. Today I am joining with other clerks across the state of Michigan, calling for federal assistance in verifying the citizenship status of those on our voter rolls. Under MCL 168.515 and MCL 168.520. I am asking for this to be done legally and in my office to ensure that the voter files are protected under Michigan law. Recently, a whistleblower who was an employee at the Secretary of State's office came forward alleging that the Secretary of State is registering non-citizens to vote. Contrary to what the supervisor of that employee told them, local clerks have zero ability to verify the citizenship status of anyone in the qualified voter files. So I am asking for federal assistance to do my duty as a local clerk to ensure that those who are registered to vote are also legal citizens. Absentee ballots go out on September 24th and time is running short. So I look forward to hearing from someone and working with someone from the federal government very shortly. Thank you very much.
Nice. So that's over to you there, Todd Blanche and the DOJ and Harmeet Dillon. And sounds like a fun town. Never been there, but maybe one day. You can see this guy also, if you missed it, his name is David Olson. So he's another guy out in Hastings, also saying the same thing, saying we need some federal assistance here. They're lying about our capabilities. They're adding illegal voters to the voter lists, saying that we can fix it. We can't do anything to fix it. And this is a curious little tactic here because we know that Harmeet Dillon and the DOJ, the Civil Rights Division, has made very clear, if you are a part of the election mechanics and you are facilitating illegal votes to get counted in any way, shape, or form, we're coming for you. We're not going to let you just say, oh, we're so dumb. Oh, it was a glitch. Oh, I had no idea. We want you to enforce compliance because, you know, that's your job. So this guy, Hastings, also said the same thing.
Hello, my name is David Olson, clerk at Hastings Charter Township in Berry County, Michigan. My county sheriff, Darleaf, had received a report today and disseminated that information that an employee at the Secretary of State advised him and said that there was proof that when a non-citizen changes their address, programming automatically registers the non-citizen to vote. When that state employee advised their supervisor, the supervisor's response was, it's okay because that will be caught downline by the clerks. That is not correct. Once it's in the qualified voter file, there's no way for me to verify citizenship, and therefore they are automatically issued a ballot or an absentee ballot. So, since it is my responsibility to safeguard the qualified voter file for our township, according to MCL 168.151 and MCL 168.520, I'm asking if the federal government is interested to help verify my citizen role. I would be welcome to have them here. I will safeguard my voter roll in the office, but they are certainly welcome to come and compare against mine. In this way, we will uphold our federal elections. We will definitely follow law, and it will be fair and honest. Thank you.
Thank you, sir. So we've got two there. And of course, we also have lawsuits that are being filed. And this was a big one that we've been keeping our eye on here, brought by Kevin Kajewski and the other town clerk called McQueer. And now we're seeing that after they sued Jocelyn Benson, she, according to the complaint, was ordering the town clerks to delete certain files. Elections would happen. She said that they would change the election rules so that the clerks had to delete files within 7 days. Problem with that, of course, is that the federal government says you got to keep them for 2 years. You have to comply with federal law in case there's an audit, in case the FBI wants to come into Fanny's land and go take those pallets full of ballots, so that we can actually validate what's going on in America. So these clerks are now put between a rock and a hard place. If they don't follow Benson, then she goes after them. If they comply with federal law, if they don't comply with federal law and do what Benson wants, they're committing a federal crime. So they're screwed either way. So now Kajewski responded to this, and he said, after the complaint was filed, Jossie Bency, she came out and issued a response, and then boom, they slammed her in response as well. So he gives us a summary here. He said, Jocelyn created a new rule that orders the clerks, the people that we just saw, to destroy election records in violation of federal law because she's a criminal. My client sued because it forces her to break federal law. Benson then filed a 23-page response. We'll take a quick look at it, trying to get the case thrown out, but not once in that entire response did she say that this new rule was illegal. She's basically saying you can't sue, like you have no standing, or you're prevented from suing because you sued too late. This rule's already been on the books for a long time. So it's like an estoppel type latches argument. So read it for yourself. We will there. And their brief tells the court that their own director of elections cannot, quote, offer a substantive argument in response to their complaint without tipping his hand. Well, this is litigation, so you may want to actually articulate your argument in your filings. And this, quote, it remains to be seen whether Jocelyn will have the same legal position regarding the rule, because it's illegal. Now, they have previously argued that the rule violates no law, including the federal law. They just won't say it to a judge here in Michigan. So what did they argue? That she waited too long in a case filed 8 days after the election. Jocelyn is saying, but the rule was on the books for a very long time. And they asked her twice to clarify the rule. Like, you're ordering us to violate federal law? Are you serious? Like, really? You want us to do that? Also, that any determination about Benson's rule belongs in a process run by the department that the client sued. So not once in the 23 pages did Jocelyn argue that a clerk can destroy federal records, because that would be admitting to federal crimes there. And that is the entire case. Okay, 23 pages from Jocelyn on nothing. Our response went in yesterday. We'll take a look at it. And their own sworn affidavit, according to this lawyer, says that they want to send election record destruction guidance, okay, to Michigan's 1,500 local clerks, all the heroic people that we just heard from, who say, we actually need help from the feds. This whole thing is so screwed up. We need law to come in and take hand in fixing it. So this guy submitted this, and we've been appreciating his filings here. Here's what Jocelyn ultimately said. I just want to share the highlights with you. You get the point of it, but they're not addressing the substance. Once again, latches, okay? You sued too late, and now we're going to be prejudiced by this, but the Michigan primaries just happened, and they just got the order to delete these records. So now they don't know what to do. Are they going to comply with Jocelyn and violate federal law, or are they going to not comply with Jocelyn, come under scrutiny of her and Big Gretch Rona and AG Dana Nessel, and then comply with federal law? So they write, this is from Jocelyn, saying that plaintiff Michelle McQueer files this late challenge to the validity of a rule, which requires the deletion of local copies of software and associated files for a preceding election from the electronic poll books to prepare for their use in a subsequent election. So now she's like, oh, we're just clearing out the hard drives so that there's space available for the next set. That's all. And it's a rule, okay? This is a rule by Jocelyn. This is the same Jocelyn who wanted to change the rules to require a presumption of validity for the signatures, trying to change the rules, not the statute, okay? She's not a legislator. She is a secretary, so they take the rules that are actually passed by the appropriate legislative body in the state, and then she just kind of interprets them in a way, then writes the rules. Then the rules go into the election manuals. Those all get deployed to the town clerks, and then the clerks follow her illegal rules that are not in strict compliance with the law. So then they say, the plaintiff says that the rule they write, which reflects the promulgation of a decades-old procedure, violates federal law. They want to stop the rule from going into effect, but they fail. Why? They haven't exhausted their administrative remedies. Not because the law or the rule is valid, it's they haven't gone through the proper mechanisms. Second, they're barred by latches, saying this rule became effective back in October, but they waited until October 12th to file her complaint. She even gives away the game right there. 8 days after the primary, that's when this issue became apparent. 8 days, election is over, they have to delete things. So this delay is inexcusable, and so therefore they can't sue. And third, even if this court has jurisdiction and latches is not a bar, the court should exercise its sound discretion and say, you have to defer to the federal lawsuit. So Harmeet, of course, is suing there to get the election records. Jocelyn, is basically saying, let the federal case move forward first before you do anything here. And finally, where plaintiff has not shown a likelihood of prevailing on the merits or articulated a particularized irreparable harm, this court should deny her relief. So nothing there addressing the actual validity of the rule. Why? Because it's illegal. It's in direct conflict with federal law. We have the supremacy clause, which means federal law reigns supreme over a conflicting state law, but she can't admit that. Now, let's not forget, there are laws and then there are rules. So, and they just race this rule through. It's pretty amazing. So Michigan law, the law passed by the legislature, said that each township should use poll book software according to MCL code. Michigan has developed its own software, and before Election Day, the cities and townships shall download the poll book software from the qualified voter file. Then the poll books are used to process the voters, then generate the precinct reports. Then they get uploaded. And, you know, what's curious here, I didn't see anything in the law that said delete all the files. So given the changes in the election processes, including the advent of early voting, then the Department of State back in 2025, Jocelyn, submitted a request for rulemaking. So the law says that. You'll notice that she didn't quote anything that says about deleting anything because it's not in there. And then the rulemaking from Jocelyn gets approved. She submits it in March, and lo and behold, March 6, 25, the rulemaking was approved. So she takes the law and then perverts it into a rule. Draft language was then approved on May 27th, which includes these details here. And this is the rule that will then go into effect, saying deleting local copies after it's been uploaded is perfectly allowed. So this is all a rule that was proposed by Jocelyn. The state legislature had nothing to do with it. So we then submitted our regulatory impact. Everybody approved it because Michigan is corrupt top to bottom. And it all came into effect. So then Congress talks about HAVA. We passed the Help America Vote Act, which they're in direct violation of. Secretary of State got 2 complaints there. And then the rule set became effective. And now we've been using it, and now we're being sued over this. So then subsequent to these other declaratory requests, we have security memorandum, then we got instant litigation. They sued. They said, hey, you are asking us to violate federal law. And then you get the gist of it because she's not making any arguments about the validity of the rule. She says there's no jurisdiction here. Okay, she didn't follow administrative law. She should have done these other things before she filed in this court. And so the whole thing needs to be dismissed basically on a standing justiciability type of issue. In this case, latches. And you can't sue now. Latches bars. This was unreasonably delayed. And no substance. Not saying it's a valid rule, as we just saw in the summary by the lawyer. Now, they've responded to her. So they're ultimately asking here at the bottom for dismissal, saying, you know, don't actually allow this lawsuit to advance. And they haven't even made a showing of irreparable harm, which might be the most insane thing in this entire lawsuit, because if they follow her lead, then these town clerks are violating federal law. So for all these reasons, deny their motion for a TRO, allow us to implement the rule, allow us to delete election records because we're cheaters. Then the lawyers responded. Okay, so this is Kevin Kajewski, who is representing Michelle McQueer out in Michigan. They've sued her and they're responding to Jocelyn right now. They say, all right, now we're responding to this. They say that Jocelyn asked this court to dismiss this right now even though they're not even defending it. Their combined brief raises exhaustion. She hasn't done administrative work enough, latches, and jurisdiction, and then it suddenly stops. There's no argument about the rule. Its likelihood of success section contains one sentence, pointing back at those procedural arguments, and their brief tells the court that, quote, the director in the Secretary of State's office, the Department of State they call it, cannot offer a substantive argument in response because it might tip our hand in this proceeding when she is kicked out of court and she goes back through the administrative processes. We don't want to tell her what our strategy is. So the secretary has then argued, they write, that in the administrative forum that the rule violates no law, including federal law, but doesn't use that argument here. How come? Because she doesn't want to be arguing a crime. That's why. And defendants tell the court that it remains to be seen whether we're going to have the same legal position at the rule when we actually have to go fight this in administrative proceedings. So the merits of this case, therefore, are unopposed, not even defending her own rule. Each of the three procedural theories that she's argued now fail. That silence from them is not academic. A clerk who obeys the rule literally faces criminal exposure under federal law and state law. Michigan says don't delete them in section 75491. So a clerk who obeys those laws must defy Jocelyn Benson and her Department of State. So here are the counterfactuals. They argue from this town clerk. The Washtenaw County Board certified the August 4th primary on August 12th. Not long ago. This is all fresh. The Board of State Canvassers must certify by the 20th day after the election, and they've done that. The recount window then runs 2 more days. The release of the security memo will issue at earliest this week, and the department will then issue deletion guidance. So after that sequence, Jocelyn sends back, delete everything. Then all of that will happen right now, and that all is done before statewide certification, before any memorandum, and before weeks before any deletion duty could even exist. So now this plaintiff, this one town clerk, McQueer, is just one of 8. 8 of them ultimately signed on to this. 7 of them are local clerks or deputy clerks, all these town clerks rising up, let's go, saying that they sent a letter back over to the Speaker Pro Tem, under the Speaker Pro Tem's letterhead, requesting a declaratory ruling on this rule, saying we don't know what to do. The letter says that the clerks are going to be screwed either way. No matter what they do, if they comply, they're in trouble with the feds. If they don't comply, they're in trouble with Jocelyn. So then on November 25th, the department answered. Jocelyn responded and said, we're going to consider these requests after the civil litigation ends. So in other words, you're not going to get an answer back in November. So they sent another request back on July 6th before the primary occurred. And the defendant, in this case, Jocelyn, she concedes the letter was apparently stamped as received. So we got the letter, and that even in the right hands, the letter ended up, and the department would not have acted on it until after the federal litigation was over. So we got your letter, but we're not doing anything about it. So the rulemaking record is as follows. Now, these facts prove that count 3 all exist and shows that a federal conflict was never even analyzed. The notice of a public hearing described in the rule set is as follows. To provide an electronic poll book in this rule, that it must have a secure live connection to the voter file if there's internet access, and that the poll book software will be downloaded and then serve as a backup. Now you'll notice that deletion is not mentioned. The agency's report to the Joint Committee summarized the rules in the same 2 sentences. The entire hearing says no individuals attended or testified. 2 comments were received. Nothing changed before the prior draft and the final text. And so there is no rationale, even in the creation of the rule, for deletion at all. So they've sued. They say we have jurisdiction. You have to deny her requests. We're entitled to judgment without delay. She's not even defending her case. So they walk us through some of the mechanics here, saying we don't actually have to exhaust this. This other case called Warren talks about lots of kind of, details here, and said even if a request were required, we had to go through this other mechanism. The department got this question twice. We already did this. Once as a signatory and once on her own, she sent it in. All of it was deferred. We got no responses in that prior case. Now here, this is even stronger. Plaintiff signed the October request and the department answered her, then sent another renewed request in July. And so no answer on that. That is a constructive denial. So we've already actually complied with the administrative mechanisms entirely. So that's an illegitimate basis to nuke this case right now. And we didn't sue too late. We sued before any deletion duty existed. After the primary occurred, that's when we had to start breaking the law. So even her own brief computes the operative deadline. She said certification happens on August 24th, the recount window 2 days more, security memo comes out August 24th, week of, and then deletion occurs 7 days after the memo. We sued on August 12th. She sued early, weeks before the deletion bind, and none of the guidance has been issued yet to actually delete these things. So a lawsuit that was actually filed before the deletion obligation even attached, we haven't slept on anything. Counting from the rule's effective date to the months now is a time in which we didn't have to do anything, but now we do, so now it implicates us. So the collision between the 7-day deletion command, it all occurred on time, and that's why we're suing. Another case anchors the point. Similarly, in Davis, same types of timeline, they had standing. There's no delay, there's no latches, and we should be here. Now, similarly, we should not be adjudicating this. The doctrine is one of discretion, not entitlement, saying the preceding defendants nominate cannot decide this case. Jocelyn says, we got to deal with the feds first, then we'll deal with you. It's not how that works. The structure that they describe forecloses deference, and we don't actually have to go through that avenue before we come here. So every injunction here favors preservation. We should not be ordered to delete anything. The likelihood of success here stands unopposed. Their entire brief was their opportunity to defend the rule and the merits of their action, but they didn't do that. On this record, the court may treat the merits that they argued and that we've argued as non-contested because they argued no merits. And there will be irreparable injury here. Remember, destroyed records cannot be recreated at any price. Deletion is the paradigm. And so equity here is to prevent an irreparable harm. That's what's going to happen. We have been very clear and have shown a particularized harm, saying that our clients, these plaintiffs, are the custodian of these records. Jocelyn is commanding them to personally destroy them on pain of criminal exposure. They'll violate U.S. law. They'll also violate Michigan law. That, more than 1,500 other clerks face the same command, is a systemic injury. It's not abstract. None of them is the general public. And so they answer a different case. The harm is destruction. They don't even talk about it. And so the balance and the public interest follow from this concept. The only conduct an injunction compels is not deleting, and it's a null act that changes nothing about the election. All we want is to preserve the records and invalidate the rule. The public has an interest in preserving these records. Congress at the federal level commanded all of that for a reason: to prevent the ability of the public to actually examine them. And so we are saying that the Administrative Procedures Act requires the hearing notice to reference the substance of the rule. The rule just suddenly came up with this deletion concept after the files were uploaded. But the record shows what such a notice produces, which is an empty hearing room. There were 2 comments on this, one praising backup retention, and the public never once got even invited to this. So the deletion command is no outgrowth of a connectivity and backup notice. The object of this is about fair notice. Then they inserted the deletion component. And so therefore, Judge, you should deny this. There is an actual controversy here. We have a right to be here. We are not prevented from actually suing here. More than 1,500 clerks administer the election, and the material facts from Jocelyn are completely undisputed. Most of them are their own exhibits, saying the legal question is whether a rule may command destruction of records that the federal government says you must retain. It's called the Supremacy Clause. It's called Michigan law. Jocelyn can't override both of those. So we once again are asking, you deny her motion, You declare the rule to be invalid, at least to the extent that it requires the deletion of the poll book records, and that she can't come after us for this. And otherwise, we think this is fully briefed and we're ready for your decision. Signed by Kevin Kajewski, responding back to Jocelyn Benson. So all of that, a beautiful filing, and it's pretty wild, right? Jocelyn will just change these things under cover of darkness and then presume that the courts will backfill her authority. But now we're starting to see some of our own lawyers and our own brave town clerks who are standing up to fight back against this. So it is a very nice development. And if you missed it, here was the Sheriff Darleaf's criminal referral. He said that another town clerk, as the prior town clerks had already said, came to him saying that there's evidence of fraud and perhaps even criminality that the DOJ should look into. This is from a sheriff in Michigan.
It's a beautiful Tuesday morning here in Berry County, Michigan. I'm Sheriff Darleaf. An employee of the Michigan Secretary of State's office reported to me that non-citizens are automatically registered to vote when they change their address. The confidential informant provided evidence that the customer and automotive record system is programmed to congratulate and inform non-citizens that they are registered to vote. When the confidential informant provided proof to her supervisor that non-citizens are automatically registered to vote, the supervisor stated that the county clerk would identify the non-citizenship status. Unfortunately, ladies and gentlemen, this is not true. The county clerk has given access to the qualified voter roll after the Secretary of State registers a person to vote. The qualified voter roll does not designate a citizenship status. Once a person is registered to vote, they have the ability to receive a mail-in ballot or vote at the poll with their ID card. The polls do not verify citizenship status. My office has referred this matter for investigation to the United States Department of Justice of conspiracy to violate 18 U.S.C. 611 and place non-citizens on the qualified voter roll and in the jury pool. Additionally, I am asking the Michigan legislature to use its resources to remedy the illegal voter registration and placement in the jury pool immediately. My office encourages witnesses with additional evidence of non-citizens receiving automatic voter registration to report this evidence to my office or to your local sheriff. You know this is wrong. It's time to act. Have a good day.
You too, sir. We appreciate that. So you can understand why they want the paper trail and the electronic trail to all be nuked instantly, so that if there's any investigation into what they've done, there's nothing to see there. But fortunately, we've got lawyers now filing all over the place in Michigan. We've got town clerks who are saying that this is enough already. It is wrong. And why do the Democrats, why do people like Jocelyn Benson issue rules that are flagrantly, openly in violation of federal law? Well, because they know there are really no consequences for them thus far. She's running for governor. She may win because they get in as secretaries, just like Katie Hobbs did. They rig the system in favor of their party. They engineer the rules to their benefit, and then they ascend up higher on the chain like good communists do. So this will be a battle that we're going to keep our eye on. Hopefully, there are many more town clerks out there that start to join in on the fun, put their names out there. It's a heroic thing to do because, as we've seen, when the left takes power, they come after people like this. They come destroy them. They try to steal their law license away. They try to destroy their businesses, destroy their families, and in many instances, they try to put them in jail, like they did with the J6 protesters, Trump's lawyers, anybody who worked on the alternate electors theory, people who investigated it like Tina Peters and more. So these people are brave. We want to send them our love and our prayers and support them and hope that they stand firm, demanding that America's elections are actually conducted freely and fairly without activist hacks like Jocelyn, who will do everything in their power to pervert the system. So we're going to keep our eye on this one. Thank you for joining and subscribing as we do. All right, we got one more update and a big win out of the 11th Circuit. Let's take a look at what's going on here, and then we'll hear from you. We got one here that is a good one. Victory on elections out of the 11th Circuit Court of Appeals coming out of Georgia, where Brad Raffensperger and Fani Willis reside. We see that this was a battle that's been brewing for years and has now been handed down in a way that comports with justice. This is about maps and redistricting. And after the 2020 census, Georgia created some new maps. But you know what happened? Those maps were a little bit too racist for some of the leftists out there. And so they sued. And a lower level judge said, yeah, this is really bad for certain ethnicities. And so you have no power to redistrict. You have to keep things exactly the same. But now the 11th Circuit said, things have changed now. Remember that beautiful case from the Supreme Court called Louisiana versus Klay, where the Supreme Court said it's actually racist to draw racist maps. Shocking concept, finally obliterated in our law, where they would say, in order to fight racism, we have to put all the black people together or all the Latinxos together, bundle them up like they would seat them on the back of a bus or something, all in a separate but equal location. Clearly racist, but in American law, it was part of our electoral process. Just carve up the map so everybody of like color gets assembled into one district. Clearly racist, obviously racist, and the Supreme Court said not doing that crap anymore. So here is the decision that was handed down. We had a lower level block from a judge, and the judge permanently blocked the state from employing several redistricting maps. Said you can't do this or use these maps in any future election because of more racism. So the district court said that Georgia's maps violated the Voting Rights Act because it was bigotry. Now, until April of this year, and when SCOTUS slapped this all down, courts in this circuit operated under a 40-year-old Gingell's framework, this idea that you could actually use racial gerrymandering to fight racism. Weirdest thing ever. And other vote dilution claims. Then, in April, the Supreme Court, on a glorious day indeed, handed down Louisiana versus Klay. Amazing. Modifying Gingell's. In doing so, Klay changed the existing understanding of vote dilution claims. Perhaps most significantly, Klay said that Section 2 of the Voting Rights Act and the power to compel race-based redistricting, everybody of like color gets bundled into one group, it falls within the 15th Amendment authority only when the circumstances give rise to a strong inference that there was actual intentional discrimination that occurred. It's a violation when there's intentional discrimination. You can't use the power to say we're fighting discrimination, and so we're going to actually discriminate and bundle people up by color. The Supreme Court issued Klay after briefing closed in this case, long after the district court's judgment. And so the appropriate response to such a significant change of law is to vacate the lower court's decision so that the lower court can reconsider this in the first instance. The lower judge blocked it, but now has to revise and review it in light of Louisiana versus Klay. So we do so right here, and we're going to send this back down and tell them follow the Supreme Court. We'll see if they do. So Georgia challenges now, in this matter, the lower court's application of Section 2 of the Voting Rights Act. But the Section 2 landscape is very different now. Georgia and the plaintiffs recognize as much, and few could deny it. Klay, the landmark decision from SCOTUS issued this year, clarifies the constitutional guardrails of the Voting Rights Act in Section 2, saying it must stay within the factors and the plaintiffs have to prove certain things. Now, as we remember, there were two challenges in the Supreme Court case. Louisiana redistricted. They drew new maps. They said, this is racist. You're disenfranchising us. Like in Georgia, Louisiana redrew its districts in 2020 after the census. Louisiana's initial map had one majority black district out of 6 total districts. Now, black voters sued. They said, you're diluting our votes. Their challenge was successful. The lower court ordered Louisiana to draw a second majority black district, okay? One black-only district wasn't enough. We need more separate but equal districts. We're going to bundle all these black people together into a new district so that they have representation, is the theory. So Louisiana did it. They complied. Then a group of non-minority voters challenged this. They said, that is literally racism. You're putting them all together. And that violated the actual Constitution under the 14th and 15th Amendments. Now, the second case, this one also is the subject of Klay. This worked its way through the judiciary as well. So then, in addressing the non-minority voters' claims that Louisiana intentionally create a second racist district, said that was unconstitutional, the Supreme Court then came down and said, the question is this: whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing districts. And they literally carve up the maps that way. You go all the way this way, all the way this way. You just find all of the people of color and put them into one group using race as the drawing mechanism. And then you say that's not racist. So in answering that question, the Supreme Court said that under the best reading of the law, Section 2 was the ability to enforce the 15th Amendment. But second, based on a close reading of the statute's text, the court also said that Section 2 properly fits within the 15th Amendment's enforcement power only if there is intentional racial discrimination. If these other maps are drawn to explicitly carve up race, people by race, and that's a key factor, then that would be racist and you can undo that map. But that's not what is happening. In fact, they're saying that race is the reason to draw a separate district in order to possess a certain group of people with more representation. So therefore, liability under Section 2 only arises when the circumstances give rise to a strong inference that they were drawn in a racist fashion. So while that interpretation does not demand a finding of intentional discrimination, it's a strong inference standard, and you can parse through that case by case. Now, among other teachings, the Court of Appeal says that the Klay Supreme Court decision also emphasized that plaintiffs also need to account for partisan concerns, saying that there could be non-racist reasons for drawing things this way. They must rule out the competing explanation of politics. Politics dominates how the maps are drawn. So if either politics or race could explain the contrast or the contours of the map, the plaintiff then has not cleared its bar. It's got to actually be racist or an inference of racism, something that is not justified by politics. But rather, since the court's decision in Rucho versus Common Cause, courts must treat partisan advantage like any other race-neutral aim. And so therefore, under the Supreme Court case Klay, any proposed redistricting plan that fails to disentangle race and partisan goals wrongly intrudes on the state's ability to actually draw districts based on partisanship, not on race, which is what they're doing. The central holdings here also reverberates. Now, although Klay did not overturn Gingles, it expressly amended it. And so therefore, now, with respect to this, the plaintiffs must show it's possible to create a large, geographically compact, and reasonably configured district that is majority-minority. In this argument, the court said you can't use race as a criterion when drawing these maps. And any proposed map must meet all the state's legitimate redistricting objectives, including political goals like achieving particular distribution of partisan voters for an incumbent. Like, you can draw political maps. That's the point. So the court determined that these changes are necessary. We have to disentangle race from politics. And so consistent with all of this, Klay says that to satisfy the second and third preconditions, politically cohesive voting by minority and racial bloc by voting, you have to also talk about party affiliation and the other politics. Finally, the court said that the totality of the circumstances inquiry must center on evidence of intentional racial discrimination about voting. This differs from Gingles, which directed lower courts to then review the totality of the circumstances to see if things were equally open to minority voters to remedy in an evaluation of past and present reality. But now, after Klay, courts must afford less weight to discrimination that occurred in the past. Present-day disparities are characterized as the ongoing effects of social discrimination. A lot of history there, then the holding is very short. Now, on appeal, Georgia says the lower court erred. They said that the new maps violated the old law. Georgia said that the plaintiffs needed to show that race, not partisanship, caused the new maps, and they failed to do that. Georgia also says the lower court misapplied Gingles and the Senate factors, so it wrongly found that black Georgians experienced vote dilution at all. So Klay then says this is all new. The lower court did not have the benefit of Klay, so we will afford them the opportunity to reassess this case under the new standard. We routinely remand cases when the Supreme Court issues an intervening decision. They cite a bunch of those there. We think this warrants this as well. So Klay and the Gingles framework leave us with questions, and the lower court should address those on the first instance. Supreme Court also reached the same conclusion there. They vacated and remanded multiple redistricting cases in light of this rule. And so a lot of this has been going on right now, and we're going to do the same thing. Now, the plaintiffs, the people suing, saying that this is still an illegal map, they say if we must remand the case, we should only vacate what is necessary and pick out what has already been satisfied under Klay. We decline. This is a very fact-intensive process, so we remand to the lower court to consider the evidence in light of the Supreme Court and take any other appropriate action. And so for the foregoing reasons, the lower court's block on the new maps is hereby vacated, and the remand to the lower court is now in effect for further proceedings consistent with Klay. So we'll see what happens and whether these new maps can get in place or not before the midterms. Somehow I doubt it. It is Georgia after all. So we'll see. But as it stands, the block that's been going on since 2020 is now going back down for further analysis, hopefully to comply with Louisiana versus Klay. Nobody's trying to disenfranchise certain groups of people, but they were drawing maps in order to create power centers using race as a proxy for Democratic votes, which is a very racist thing to do, by the way, to say all black people are going to vote Democrat. It's largely true, but it's not uniform. But that's how they're treating people. So the Democrats, well, in order to fight racism, we have to be racist and draw these maps, and then we'll get seats in Congress, and we'll continue to maintain our power. And what we've seen in the aftermath of the Klay decision is that states are redistricting, and it's becoming a more representative, politically organized system rather than a racial system. So it's all good news. But we also know that this is Georgia, and the election system is pretty perverted out there. And so this was a clip of Cleta Mitchell. She's over with the Election Integrity Network, and she was dropping some numbers for us about what they actually found out there. So the problem here is it's seemingly, and we heard this from Dr. Janice Johnson, who was on the state election board as well, we have a situation where there's more voters or more ballots, more registered voters than there are people living in these various locations, which seems like that's impossible, doesn't it? Here's Cleta Mitchell explaining some of the numbers here, and they are quite shocking. So even though there's a new map that is likely going to be coming in Georgia, the votes are really whatever they want them to be.
Post-election, there were 148,319 absentee ballots in Fulton County counted, included in the totals for Georgia. But only 125,784 voters were recorded as having cast an absentee ballot.
What?
That is a difference of 25,535 more ballots than voters who are recorded as having registered for and cast an absentee ballot in Fulton County.
Wow.
So that's 25,535 more ballots than voters. And the margin between President Trump and Joe Biden was 11,779. Now, these absentee ballots that came in, there were over 133,000 ballot images deleted. Only 16,000 of the 148,000 absentee ballots, only 16,000 have the actual ballot images that were retained as required by law. And people have looked at those ballot images and they see anomalies, markings, changed timestamps. They believe that those were deliberately deleted.
Yeah.
Now that's just in the absentee ballots. We get into the tabulators, where the tabulator tapes, that every tabulator has a tape. It is supposed to have a memory card that is put into the tabulator at the beginning. They're supposed to print out a poll tape that says 0. There are no ballots on this machine at the start of the election. And then there's a memory card that's supposed to be put in. There's a seal that is put on, and that is not supposed to be taken off until the polls close from advance voting prior to Election Day, the Friday before Election Day. But what we see in Fulton County, and there's also supposed to be a closing tape.
No.
So there's supposed to be every tabulator, a tape that has the opening at 0, and at the closing, it's supposed to say how many ballots were tabulated by that particular machine. It is supposed to have the serial number of the machine that actually tabulated the ballots. What did they do in Fulton County? There are only 9 tabulators that have opening tapes. There are zero poll tapes that have both the opening tape and the 0 count, the official record of how many ballots were tabulated, and the serial number. There are 0 of the 148 tabulators in Fulton County in 2020. There are 0.
She's amazing, and you could see that report was scrolling down from her over on the Election Integrity Network. And so Georgia's new maps may go into effect, but if they're just running their elections like kids in a candy store without any supervision, they can get whatever outcomes they want. So we're going to keep our eye on this, but in the court of law, we do have a victory. The lower level judge has now been vacated, and so the process for implementing these new maps can presumably go into effect. We'll see what happens down when the case is remanded back down to that judge, but the Supreme Court has spoken. And so another redistricting victory lands on our desk. We're happy to see it. We're going to keep our eye on this one and all of the election litigation moving forward. Thank you for joining us as we do. All right. And so, friends, if you're just getting here, what a beautiful day it has been. Big battle back and forth between Indira Talwani. Let's do another refresh on this one to see if there's anything else that dropped today. Nope, nothing else from her. So they'll be able to amend their complaint. That's going to be a very sneaky little battle here. But Indira Talwani, she got slapped down from the Supreme Court yesterday. They said, you have no jurisdiction over these lawsuits. All the blue states who sued did so prematurely, complaining about nonsense that's not even in the order. There's no violation of the law, and you have no standing. So get out of here. Then, of course, we know that she is presiding over 2 cases. Very strange, just like Jeb Boasberg, who got all the illegal immigration cases with MS-13. She gets the election cases, and today the DOJ fired at her, respectfully, saying you are, respectfully, an idiot, and you're not allowed to also continue an injunction in the League of Women Voters case. If SCOTUS slapped you down when the blue state sued, you can't continue a separate injunction in a parallel case from some nonprofit who has whiny members. But she responded in a weird filing and said, you did violate my illegal injunction, but I'm not going to do anything about it. I impose no remedy other than identifying the violation, which is like embarrassing. Indira, it's embarrassing. Come on. What are you doing? You're an adult. You're a federal judge. Have some self-respect. So goes through, you violated my order, but I'm not going to do anything about it. So it's like, whatever. I'm not even grounded. Who cares? So then, of course, gives away the game. She knows she can't do anything because the Supreme Court said the whole thing's illegal. So tremendous victory, even though she's throwing a hissy fit about it. We also saw the American people want this thing done. We have polls that show everybody wants elections with integrity. Base Mike Lee calling out John Thune today saying, can we come back to the Senate and do something useful, please, for once in our lives? We also then went over to Michigan. We have multiple town clerks now who are emerging one after another, like American heroes, and explaining the fraud they're seeing right now before the midterms even land upon us. We had this lady. We had this guy. We also saw Sheriff Darleaf. Again, we played this clip previously, but he is again also in on the game. We also looked at Jocelyn Benson's lawsuit. So she's being sued by Kyle Kajewski and another town clerk called McQueer, who are saying that Jocelyn is ordering them to literally delete election records. Jocelyn kind of didn't respond. She said, well, you can't sue me because of justiciability issues, refusing to even defend her lawsuit on the merits. And then the lawyers responded and said, wow, that's really pathetic of her to do that. She won't even defend her own rule, which means we win by default. And every other argument about why we can't be here is invalid. We absolutely can be here. We've exhausted all of our remedies. We sent her multiple letters. She's not responding to it. And her rule is in violation of both Michigan law and federal law. But she wants those records deleted, man, because if there is a chain of custody, she doesn't want anyone to find it. So we got through that. And then we had the 11th Circuit victory, Georgia redistricting, now back on the menu, boys. So we'll see what happens when this goes back down to the lower level court. But it was all being stalled out. Georgia drew new maps in after the 2020 census. Leftist groups like the African Methodist Episcopal Church and others sued, saying this is discrimination. Lower court blocked it. Supreme Court said you can't actually draw racist maps anymore because this is America. And now the 11th Circuit saying that's exactly right, sending it back down to the lower court for remand and to reconsider the arguments in light of the Supreme Court decision. And of course, we got ourselves some Cleta Mitchell in the house, always enjoyable. So now, my friends, it is time to hear from you. I hope your week is unfolding beautifully. You're accomplishing everything you set your mind to. We're glad that you're here. Thank you for subscribing to the channel, because we'll be back this week with a whole lot more. A lot of election news today. We'll see if that continues, but anything that is about justice in America, we're going to be here to cover it. So we got a bunch of new members today, my friends. What a glorious day it is. And we had a great members only stream this morning. We had a couple of wild segments this morning. We talked, first of all, about the Canadian trade war and Lake America, which is much better than Ontario. We also then talked about a judge in, I think it was Michigan. Was that Detroit, Michigan? This crazy judge who put a 15-year-old in handcuffs. She was a student there for a student field trip. And she fell asleep when he was giving this boring lecture about how amazing he is. Fell asleep. He put her into custody, put her in handcuffs, said we're going to teach her a lesson, was live streaming the whole thing, ordered her to strip down and put on jail outfits. And then she didn't do that. So they just put it over her clothes, brought her back in, had a mock trial where her classmates were going to convict her. And her family's now suing the judge. He claimed judicial immunity. He just got backhanded from the Court of Appeals. It was a wild case. And then we also talked about there's this other lady called Kilo, who is a naturalized citizen who was running for office in New York. Turns out she was trying to siphon $1 million out of the public funds matching for her campaign cash, was using that campaign cash for her own little extracurricular activities. She actually was not indicted, but she just pleaded guilty to a criminal information. We went through that criminal information and got to see what a total scam it was. So we had a good morning stream. Check that out if you're looking for more legal news to get into. And then, of course, we'll see you back here tomorrow, 10 a.m. Eastern time, for a beautiful Wednesday. And we're trying to line up some interviews also this week. I've got one scheduled on Friday with a gubernatorial candidate actually out in Michigan. She's running. She's a part of the Freedom of Taxation Party, something. Great lady. I had a phone call with her, and I think it'll be a fun one. So she's joining us on Friday. And then I've got a couple of other messages out to some other people who can hopefully join us, maybe even this week. Good stuff. And now, my friends, it is time to hear from you. What a beautiful day it is. Richard Tatership, thank you for sending that one in this morning. We have, here's Trump with an orangutan, one of my favorite animals. They're pretty amazing. It's wild how strong they are, how they can just move around, pick their whole body up with their pinky, just super slow-mo, I'm not even exerting myself as I'm lifting myself up with my pinky up this tree. Pretty amazing. Shout out to President Trump. Man, even the orangutans like him. Hey, what's up, Tim Jake? Thank you, Tim. There are some who call him Tim. Thank you, Tim, for bringing in 5 new members. What's going on? Mind Weavers is coming in. We got Bryce Mearness. What's up, Kenny Lewis? Real Digital Zoo AI. and D Alpha Omega, all gifted members courtesy of Tim Jake. There are some who call him Tim, and we call him, thank you, Tim, for bringing in new members. That's our nickname for him. NC November Girl sent a loot box. Man, thank you for that, NC November Girl. A little bit of a gift there. We appreciate you for sending that one in. Sev Russ, what's going on? Sending in 5 new members. Thank you, Sev, for doing this. We got Cheyenne KM, welcome. Jan Monroe in the house. Welcome to Green Eyes. We got Miscellaneous and George W. Bush Center for Intel 147. Welcome. George Bush Center for Intel in the house. We also, and thank you, Sev Russ, for sending in 5 new friends. We'll see everybody in the morning. I'd rather be skiing. What's going on? Says, from the DOJ to leftist. To leftist judge, this is an email, subject, your ruling, message, eat it. Best regards, Department of Justice. I hope that's real. It feels real to me. It's kind of what they were saying today. I always like, also, instead of best regards, sincerely, your friend. Eat it, sincerely, your friend, Todd Blanche, you know? Because it's just so condescending. It's just so enjoyable. You're the worst person in the world. You're a disaster for humanity. And we hope that there are serious legal repercussions coming your way. Sincerely, your friend, Rob. Send. Perfect. Hey, I'd rather be skiing. Thank you for that. Also, hey, Fun Shine Kelly. What's up, Kelly? Kelly S. in the house. Sent in a marshmallow. Thank you, Fun Shine Kelly. Marshmallows in the house. We also got, Rob says, from the DOJ to leftist judges, bite me. Sincerely, your friend, Todd Blanche. Thank you, Rob, for that one. These are good emails. I hope they're real. Kimberly Suzuma, what's going on? Sent some gold in the house. What a lovely day. Thank you, Kimberly, for sending in a little gift there. Rob, what's up? Rob, explain the difference between U.S. Code and the U.S. Code of Federal Regulations. Yeah, so it's almost exactly like what we talked about in Michigan today, in fact. So there is U.S. Code. So like when Congress writes a new law, they change the U.S. Code. We see that, and they can also change the CFR. But think about the regulations as something that interprets the code. Okay, so just like Jocelyn Benson was doing. Jocelyn Benson gets the statute. We just read this. Michigan passes a law. Then Jocelyn goes and wants to propose some rules that interpret the law. The law can be very cumbersome, right? It's not that understandable. So then you need regs that kind of articulate how the code works. So it's like another layer. And they basically refer back to the code and help you understand how the code is implemented and how to operate under the code. Jocelyn's problem was Michigan law was very different than the rule that she was implementing. Some would say illegal, not even allowed under the rule. And so there's a possibility for a disconnect between the two, but they should be in alignment. Like the CFR should not be adverse to U.S. code. It should just be an explainer of the U.S. code. So it's like another layer that is broader than the U.S. code. So hopefully that helps. But we have a lot of laws and rules and things like that. So oftentimes you'll refer back to the regulations, and the regulations will reference back to the code. What's going on, Rob? Thank you. Biology always wins in the house. Thank you, Biology. Look at this. We got 20 new members coming in. It's a beautiful day. Thank you, Biology. Bringing in Joe Booty. What's up? Joe Booty is here. We got Marlene Bridgette is here. Welcome. Charlie. We got Ma Will 999. Jill Craft. We got Kevin Ashley. Spiteful B-Word in the house. Welcome. Snellfurs. We got Unwokey. Lynn ZB. Welcome. We got Fallion Zane. What's up, Jess Gars? Hoopman. We got H-Rod Wolf. My Crystal Concept. Carrie C. What's up, WCO? PhD in the house. Shadow 1869 Night Crew. Good to see you. We got Robert Gomez also here. All gifted memberships courtesy of our friend Biology Always Wins. We'll see everybody in the morning, 10 a.m. Eastern time. It'll be a good one. Bill Dozer, they won't pass the SAVE Act. They don't want to fix the problem because that removes the good old Hegelian dialectic. Yeah, so like problem solution, or like I think it's actually thesis, antithesis, synthesis, officially, right? And so you've got this cause, reaction, solution, and you make your grift in the gray area. Oftentimes, I think our leaders will actually engineer a problem so that there can be a proposal of a solution, and then the remediation of these two components equals a synthesis that enables them to do what they want, like they did with COVID or January 6th. Thank you, Bill Dozer, for that. Great comment. We appreciate you watching on Rumble. Hey, Mock Schnell. Good to see you, Mock Schnell. Back in the house. Bringing in 20 new friends. What's up, Texas Gidget? We got BTW, yikes. What's up, Lord Harry Maguire? We got F the BS, 1776. Dewey Yox. Edgar Styles. What's up, Kevin Kirk? Destroyer. We got Douglas the Corgi. What's up, Corgis? We got Recovery Hughes. Dark Prime. We got Sasha Stevens. SVR Overkill. What's up, Insidious Rage? BWC, WXX. We got Antonio Mendoza. Pelicans is here. Sarkush, Train Fighter, Jeterson. Welcome. In the house. What's up? Just Mine, AZ, and Matt Malley. All gifted memberships courtesy of Mock Schnell, bringing in new friends. Thank you, Mock Schnell, for doing that. We can't wait to see everybody in the morning. Lots of new members. Welcome, my friends. Philip Butler. Climax, Michigan is not far from hell. Yeah, it sounds like an interesting town. Could be an interesting place to visit. Like, why is everybody so happy here all the time? What's going on here? You go to a restaurant, you hear screaming in the kitchen. You're like, what is, I just want some eggs. Unfertilized, please. Good Lord. What the hell's going on out here in Climax, Michigan? I don't know, but I had to do a double take on that sign. Does that say Climax? I think it does. All right. Hey, Philip, thank you for that. What's up? Loose the Dog. Pass the Save America Act already, for the love of all that's holy. John Thune, we need you to do it. Make Base Mike Lee happy, you know, and America happy. There's a lot of people who want it done, including Democrats. So thank you, Loose the Dog. Thanks for watching on Rumble. What's going on? Tom Demos. Hey, welcome aboard, Tom. Thanks for signing up. Supporting our work here, becoming a member. We'll see you in the morning. It'll be a beautiful day. We'll have a great stream. Wednesday, all downhill from hump day. What's up, Indoctrination, my friend? Thank you for the raid. Great to have you. Shout out to our Indoctrination friends. Hopefully you enjoyed the stream. Thanks for sticking around. Roscoe the Rev sent a high five, or sent, what's this one? Sent hiding, which again looks like a little baby to me. I got baby on the brain. Thank you, Roscoe, for that. We also got I'd Rather Be Skiing, 35 months as a member. Thank you, I'd Rather Be Skiing, especially in the summer. You know what I mean? What's going on? 35 months. Thanks for being here for so long, too, by the way. That's a long time. We've got a lot of changes that's happened in our country. God bless Dolly Parton. We'll miss you. I know. I saw she passed away. Trump even commented on that today. She was an American icon, 100%. And may she rest in peace. We appreciate her legacy and all she brought to American culture. And so thanks for shouting that out. Dolly Parton, we'll miss you. 35 months. Thank you. I'd Rather Be Skiing. And this one from Sassy Gemini. In honor of Glenn on YouTube. Man, what a handsome dude this guy is, Glenn. Look at you. I made this special YouTube membo emoji. It's Glenn's face, but it's also to honor all J6 survivors. Because the details can't be seen in the small emoji size, I thought I would share it here for everyone to see. Thank you, Glenn Croy, for your personal sacrifices and representing all of us. Man, shout out to Glenn. Shout out to our J6ers, man. We appreciate them. Yeah, they got dragged through the gutter by our crap government, and we're glad to have you here. Thank you, Glenn. And that comes from Sassy Gemini, a.k.a. Just Rhonda on YouTube, who is, of course, our purveyor of fine emojis here. Thank you, Sassy Gemini, a.k.a. Just Rhonda. Glenn Croy, you look amazing. Hey, it's Data. He was great. I like The Next Generation. It was a good Star Trek one with Jean-Luc Picard. Engage. Hey, Data 12, hit the thumbs up. I agree with the mods. Thank you, Data. This is one of the best law news reviews going on. Knowledge is unique. Robert is working hard and we get the benefit out of it. It's appreciated, Robert. Thank you, Data. I really appreciate that. Data 12. Thanks for watching on Rumble. Thanks for the donation and the support. We appreciate having you here. And, you know, we think it's important. We think that this is a good way to help people understand what's actually happening here. because a lot of it no one talks about. It's just like, the same 2-minute regurgitation of whatever. And this is really important stuff. They're trying to rip our country away out from under us. We're not going to let it happen. Thank you, Data. Very nice of you to say that. And thank you for being here and making our work possible. Very nice of you to do that. Hey, Dark Rogue. Yeah, thank you, Dark Rogue, in the house for this nice one. On the appeal, party affiliation is everything. Dividing by race isn't racism because it feeds the political goal. They've been Soviet-like for a long time. Party power means everything. Causes are tools for that power. Yeah, I think that's exactly right. Like you're seeing this in New York. We talked about that one, I think, yesterday, Dark Rogue. It got drowned out by the Supreme Court, tremendous victory. But it's exactly right. Like Mamdani, the commie up there in New York, he is now creating a new infrastructure for these government subsidized grocery stores that are ultimately, according to the Minority Business Coalition that we read yesterday, they're suing him, that's going to destroy Hispanic and Asian grocers in New York. So while Mamdani rises to power with this coalition of people of color and the oppressed and whatever, once he gets power, then he does things that will destroy them and crush them because they're just means to an end. It's about identitarian politics. You bundle everybody up into these groups. Each one of them is a victim. And then you create a coalition of all of these victimized groups that you are going to represent and deliver a solution to their victimization. Problem with that is like we're seeing with Mamdani. Eventually, you're going to get the victim Olympics. And no, I'm oppressed. No, I'm oppressed. No, I'm oppressed more than you. No, I'm oppressed more than you. And of course, they also have a lot of, I would say, shared belief that their victim, their abuser, the predator, is all one group. So they can all point to one group, which typically is, white men and Christians. So they just identify them as the oppressor. They are the oppressed, bundle them together, but eventually you're going to have to start delivering policies, and policies will then prioritize certain groups over the others, and then you have this, intra-party warfare. But it is all about power. They're just ends to a means to an end. And ultimately, I don't even think many of them believe what they're saying. It's like you hear these leftists, like you heard that Al Sayed, who's like equating circumcision with chopadicophamies. Like it's the same thing. Like, what are you talking about? Does he really believe that? Like, would he go do that to his child? Of course not. Like, they're not friggin' crazy. But, in a way they are. But they'll say those things in order to placate and sell themselves to one particular class. But they don't, come on. Who wants to go lop the thing off your child? Nobody. Except, this certain group. So Gauntlet KI, thank you and Dark Rogue for that. Gauntlet, clerk was told to delete a record. That's criminal solicitation. Yeah, and people are asking, why is that sheriff just not going and arresting her? Probably not in her county, but you get the point. Like she's ordering an open violation of federal law. So almost as though she is soliciting and facilitating federal crimes. Maybe there should be charges for that. And that's part of the reason we're so happy that they're asking for the DOJ to come in here and step in to help them out and walk through this. Hey, Roger B, what's up, Roger? Not even a member, bringing in 20 new members. So nice of you to do that. Seeing we've got now, courtesy of Roger B, we got Johnny Arbor, what's up? Teresa, we got Super No Bros, we got S Mac, Demon J, Willie Gilligan is here. Sarah Me, what's up? Diana Haldy, Gina Lanning, Jojo Emmett, welcome. Mason Bug, we got Emma Jays, Remy James, what's going on to Janiev, Dalrant Barrett in the house, David Skranko, welcome. Eden's Vision, Gabby, Dracano, and Andy Keating, all gifted memberships, courtesy of Roger B in the house. Man, thank you, Roger, for doing that. Very generous of you for bringing those folks in. What's up? King of Biltong is here. You know what to do. It's BiltongUSA.com, man. Delicious meats delivered to your door. Don't waste your time on gas station junk food. Pack Biltong from Biltong USA. It's clean. It's got protein. It's grass-fed, air-dried, and it's got great beef flavor. And if you go to BuiltOnUSA.com, you can use code Robert, and you'll save 10% off. Hey, Kuda, is there a way to remove Talwani or any federal judge? Yeah, impeachment or jail, which it almost never happens. Like, no judges get removed. It's been like a handful, like less than 12, I think, ever been removed. Largely, it's when there's bribery or something really egregious. But yeah, Congress could impeach these judges. They won't, and they never do. There's been some applications submitted. Like, I think there was a couple Congress people submitted articles of impeachment, but then they go on the committee where they go to die. Nothing ever emerges. And then, of course, you need the Senate to ultimately convict them and boot them out. But yeah, I mean, there is a constitutional mechanism. Congress is supposed to act as a check on the judiciary. The Supreme Court doesn't want to check itself because the judiciary's power comes from its legitimacy and credibility. So if the Supreme Court then starts, overly with a heavy hand coming down on the lower judges, then the Supreme Court looks politicized, and they don't want to do that. They also don't want to say that our judges at the district court level are partisan activist hacks, because then people lose faith in the system. So SCOTUS won't regulate because it doesn't have a lot of power. Like, the executive has the DOJ, the FBI. Congress has the power of the purse. They can hold committee hearings and subpoena people in. But the judiciary, it relies largely on faith in the judiciary, so they don't ever want to highlight their problems. So Congress needs to check the Article 3 courts, and they just don't, because they don't do anything, really. Rob, you said that voting and registration in Georgia was like kids in a candy store. I think it's more like a smash and grab crime. Yeah, that's a better analogy. I'll have to start using that. It is. It's like smash and grab. It is. It's like Black Friday at one of those Walmart stores in certain locations across America. They're like running out with big screen TVs under both arms, except their votes. Yeah, kids at a candy store. I think I added in without supervision, but your analogy is much better. Your metaphor is better. LZ, why is there no such thing as contempt of the Supreme Court? I mean, I think that there is, that, they could absolutely come down with a heavy hand, but as I explained, they just won't. They just kind of want to, let it work itself out rather than step in and do something about it. Hey, what's going on? Mark, scrap the caddy Clyde. Scrap the caddy Clyde. Man, that's a really mysterious comment there, Mark. Very mysterious indeed. Thank you for that. Sharpie guy. Rob, you say a lot rule or the rules, etc. What are you referring to? What rules are you talking about? Where do the rules come from, or where are they written so I can follow the rules? Blessings, watchers, and Gouveias. Thank you, Sharpie guy. It really depends, I think, on what we're talking about. So like I think you're referencing the Jocelyn Benson case. She wrote actual rules, like in Michigan. So almost like the CFR, there's law, then they get rulemaking. So the rules can interpret the state statute, and then people can follow the rules, and the rules will then translate into the election manual. Then it'll be in a physical document that goes out to the clerks. So it's like this game of telephone where everything gets a little bit perverted, like a copy of a copy of a copy of a copy, then turns into something that is unreadable. But there's many rules. There's rules of evidence. There's rules of criminal procedure, rules of civil procedure. So it really kind of depends. But if you want to follow the rules, there's a lot of rules to follow. So good luck, I guess. I mean, there's a lot of rules out there. So it's context dependent, but that's where they come from, Sharpie guy. So in the Jocelyn case, she basically wrote them, and we saw that. John, what's going on? Hey, an off-label pod, don't forget about Vanessa Lopez from Rhode Island. Sent you the message about her. I remember that off-label pod. Thanks for the reminder on that. We appreciate that. Yeah, she's running for office, I think, in Rhode Island. Thank you, off-label. We appreciate that. John, hey, the Me and Little Andy song you sang the other day was Dolly Parton. What? The Me and Little Andy song. Was that the song I didn't recognize? Yeah. Dolly Parton, I mean, I remember her, but I think she was a little bit before my time. Like when I was coming up, teenage Rob wasn't like, oh, Dolly Parton. Well, I was like, oh, Britney Spears or whatever. It wasn't really Dolly Parton during my era. But I definitely knew who she was because all the older dudes were like, Dolly Parton, huh? I'm like, all right. So thank you, John. So I probably didn't recognize it, but I definitely know who she is, and I've seen her in, as an American icon that's been, who's been basically like without scandal, right? Like there's these people that just have like no scandals who are just like bona fide icons in America. So shout out. John, what's up? Hey, thank you, John. Oh, Jim tells you we got a little raid going on. Amazing. And shout out to Jim tells you. He'll be live streaming here in just a minute. Hey, is this a new one from Geegum Geegum? Man, amazing. I wonder if Joey is around right now. Joey is here. And let's see. Yeah, here he is. Let me see. He may come down here. All right, so we'll take a few more comments, and then my bro Joey may be here in just a few minutes, and we'll share that one with him. And I think I had a couple others queued up because Geegum, I know you made like several of these, and these are just awesome. So let me see what I did with them. Are those on my desktop? I don't remember what I did with them. There it is. Boom. It is. All right. So Joey is in the house, man. He's coming in here right now. And I can hear him coming down the steps. Let's open some of these up too. Come on in, man. Your fans are waiting for you.
Asafisa. Yep, that's me, Tommy over here.
Yeah, that's you, man. So here's what we're looking at right now.
Go ahead.
So your fans are here. You want to say something to them?
T7 is coming out. And the war and Find the War is coming too.
You want to scoot down a little bit so they can see your face?
Yeah.
All right, give him the update on Terminator.
Yeah. Well, yeah, the Schwarzenegger, he's getting old.
Yeah.
Yeah, that's true, yes.
He's getting a little older. He still looks good.
Yeah, he is, yes.
You look good too. Look at this nice shirt.
Yeah, Orlando, Florida.
Yeah, nice fresh shirt. We love it. Your hair looks good.
Yeah, that's true, yeah.
Yeah, look at that hairdo, man.
Yep.
How you like being in D.C.?
Well, it's pretty... This is okay a while.
Well, you got to meet your...
Yeah.
Your, what's he called?
Wait. Washington, D.C. from an old movie filming called True Lies.
Yeah.
His heart's getting tired in the movie. And he followed the bad guy fell up the roof and tried to catch him.
Yeah.
And the T7 in the war. What's kind of Skynet.
Skynet.
Yeah, same town. It was Future War.
Yeah, those are good movies.
Yeah, it's pretty good. Yes.
True Lies.
Yep.
It's a good one.
Yep.
So who did you meet when you got here?
I mean, me, his son, Gannon.
Cannon, yeah.
Cannon boy.
Because what's your name to him?
I'm still uncle to him.
Your Uncle Joey.
Yeah, yeah.
It's pretty good, huh?
Yep.
What do you think about your new nephew?
Cute, but it's kind of like a gerbil, like an animal.
He looks like a gerbil?
A cuddle, like a hamster.
All right.
Yeah.
That's good. Well, so Giga made you some of these. What do you think about this one? Here, let's show these right here.
Pop it up.
All right.
I love that idea.
You like this one?
Yeah.
Pretty cool, huh?
I am still Schwarzenegger.
Yeah, baby.
Yes.
Looks pretty cool, huh?
That's true, yeah.
Only sometimes, not all the time.
That's true, yeah.
Yeah, only sometimes. Because sometimes we like Joey, too.
Yeah, call me on anytime you want, my fans.
Yeah.
I love it.
All right, so that's that one. Let me show you another one.
Okay, yeah.
What about?
Oh, my God, yes, I like that one.
Heck yeah, that's pretty cool, huh?
Yeah, put it on the TV and mommy wants to see it.
Yeah, well, we can share them. We'll save these.
Yeah.
We got a couple more. How about this one?
That's a good one.
You like it?
That's cool.
Heck yeah.
Yeah.
Yeah, Giga made these. A lot of your fans out here are making them for you.
Thank you, Gene.
Giga in the house.
Jinga. Thank you.
Yeah,
she
did a good job on these, huh? And then I think we got
Commando.
Oh yeah, you like the Commando? Commando one. Here, let's pull this one up.
Yeah.
Oh yeah, that's pretty cool.
Yeah.
And then let's see what this one is. Pull this one up.
Ooh, that's what I'm talking about.
Nice. Also amazing.
Commando.
And how about this one?
Oh my God, yes.
Pretty cool, huh?
Yeah, that's true.
Yeah, man.
Don't forget Terminator 7 and then the War Patrol.
Yeah. Is it really coming out? Terminator 7?
Yeah, it's coming out soon. They'll find the war too for that.
Man, I'm excited for that. What's your favorite Terminator?
I like T1, T7.
T1 and T7?
1, 2, 2, 7. Yeah.
What about T2?
That's okay a while too.
I think that's my favorite one. With the T1000, the liquid metal guy.
No, he's a bad guy because he was John Connor in the movie or something.
Well, he was a bad guy, yeah.
Yeah.
Good stuff. Well, man, everybody's so excited to see you. They're saying, "What's up, Joey? We love you." And they like your photos.
Nice.
They like your movie reviews.
Yeah, that's true.
Pretty cool.
Hey, don't forget T7 and the War Patrol.
T7.
Yeah, I'm sending to him on his phone.
All right. Yeah, I'm sure they can work on that. They're pretty good.
Yeah, that's good, love.
Well, what else is going on? Is it dinner time?
Yeah, right now, yeah. He gotta go. You need to wrap it up.
Okay, I got to wrap it up. It's dinner time?
Yeah, there's one. Almost ready right now.
All right, man. Well, thank you for coming down and saying hi to everybody.
Always, I'll be back and awesome pizza, baby.
Nice.
Call me Schwarzenegger.
All right.
All right, thank you, guys.
You're the man.
Thanks, Bob. FC.
Love you, brother.
All right, thank you.
All right. So that is Joey G, a.k.a. Arnold Terminator in the house. And he loved those. Friends, thank you for making those. Jigam, thank you. Ultra special shout out. You crushed it on all these. These were amazing. So we'll save those, send them to him, and he'll be excited for quite a long time. So awesome to do that. Joey in the house. That's my brother Joey. And he got to meet his nephew. And so they're having fun up there. So thank you, friends. He loves his fans, and you're amazing to him. So we're grateful for that. What's going on? We had a couple other comments, and then we'll wrap it here and go have some dinner. You heard the man. You got to wrap it up over here. All right, so Mark, what's going on? The meme of Trump with Clyde in the trunk. Oh, that's what that was? Was that from a film? Oh, I thought that was just a cool image of Trump and an orangutan. Is that from a movie or something? Oh, all right. So it's actually from like an actual movie. All right, I didn't realize it. So thank you for that, Mark, for the clarity. Your boy is a pop culture rube, let's say. Sharpie guy. Rob, I went to breakfast last Monday at a Mexican restaurant, and ever since, my credit card has one after one charges. It's named La Popular in San Antonio. Just warning my San Antonio residents, brother. Well, that's not good. They're continuing to charge you? Man, did you try giving them a call? You didn't leave it there, did you? That's interesting. Sorry that happened. Hopefully the burrito was worth it. Rob, the CFRs are mainly written by different departments, like the DOJ writes rules for the department and they publish them in the Federal Register for discussion. Yeah. As an interpretation of the law, right? Like they're not writing laws, they're writing regs to interpret the laws. Thank you, Rob, for the clarity. What's going on, Sharpie guy? Hey, Joey, this is for you, pal. Amazing. And Jigam, thank you for sending all those in. And Natalie Ray. What's up, Natalie? Thank you for being here 16 months. You're amazing. Joey T3 and the Canninator. Love it. So good. Yeah, and he loves Arnold, man. He is his number one fan. So it'd be cool if they could meet. I don't even know what he would do, but that would be amazing. Natalie, thank you for that. And thank you for being here for 16 months, coming up on 2 full babies in the house. See if we got any other comments, and then we'll wrap. And of course, we'll be back in the morning. And I'm sure we're going to be seeing a lot more of Joey. He loves to come say hello. He's got good movie updates. It's not just Terminator. He also knows, he likes the Terminator face swaps the best. I don't think anything else could hit like that. But I think that, he also knows he knows what's going on with all the movies. He's a connoisseur. Amazing dude. Hey, what's going on? We got some other comments from Barry. Hey, afternoon, Rob. Good news indeed. Indeed, Barry. Rick D, very sad day. Dolly Parton is an absolute legend and will be missed worldwide, from Rick D in the house. Indeed, Rick. Thanks for sharing it. And Rick D, I'd chip in for fuel for this one. See what that one is. Thank you, Rick D. Fuel for this? Is it a spaceship? Barry, there is a hell, Michigan. Oh, is that what that comment was about? It's not far from hell. So like climax and hell, like hell's an actual place. I thought that was just a figure of speech. Like climax is not far from hell. But I misread that. So like hell is like a real place in Michigan. Weird times out there. Hey, Rick D, this is absolutely disgusting. Stealing from the graves of my brothers and sisters in arms for a few dollars of metal to make money. Wow, that is disgusting. This report from 2ABC, veteran grave sites robbed of headstones. What kind of a sick person do you have to be to do that? Ugh, terrible, Rick. Thanks for sharing the video. Barry, Uncle Joey, that's right. Sandra, love True Lies. And have you seen the new Spider-Man? No, I haven't, but I heard that people really enjoyed that one. And no, I haven't seen it though. Maybe we will. Maybe we'll watch that together. But yeah, True Lies is great. Like, I love that movie. I've watched that many times, maybe too many times. It's a good one. Good stuff. Okay, so friends, we'll pause here on the afternoon. Let's see if we got any comments over on X, and then we'll call it. And of course, we'll be back tomorrow to unpack the day's activities. No doubt about it. Hey, Charlotte, what's up? Awesome shirt. Universal parks are better than Disney parks. What's going on, Charlotte? Thank you for that. I know, and it's a nice looking shirt. Sometimes, man, he rides those shirts hard, like into oblivion. He looked very good today. I was pleasantly surprised. What's going on, John Peterson? What better way to incriminate someone than by their own doings? LOL. Midterms are going to implode the left. I hope you're right about that, John. Yeah, so she won't even defend her own rules because she knows it's illegal. Thank you, John. What's up, CR Citizen? Georgia maps. Under the Constitution, there is not a single mention of political parties. They have no right to be enfranchised. Washington spirit of the party. Article 1, Section 2, Clause 3 says to count persons, not party, race, sex, etc. Yeah, I think if you were adhering, explicitly to the Constitution, then maybe you wouldn't indulge in parties. But I think it's just become, an organizing thing in order to facilitate elections. It's like too many choices. People don't know what to do. It's very confusing. So the parties have just been like a natural development. But I agree. I think that the two-party system is not really ideal. In many ways, it turns out to be a one-party system, and we all get hosed. Hey, Kurt St. Angelo. You are amazing, Robert. Every day, thank you. Hey, you're amazing too, Kurt. Thank you for joining us today. And thank you for saying that. Really nice of you to do that. What's going on, Kurt? Thanks for that. We got Neuro D sharing watchingthewatchers.locals.com. An amazing place to come join our community, meet some new friends, get in on the morning shows. And of course, you can also do that on YouTube. We had a bunch of new members who joined us today. We're excited to see everybody tomorrow and have some fun to see what the Wednesday has in store for us. But we'll pause here for the evening. Big shout outs to our mods and meme smiths. We got Muffin Rando joining us. John in the house. We got Donut Mind Me. Shout outs to K Bean in the house. Neuro D, Janek and Dog Digger with our Rumble friends. We got Geegum Geegum, Elliot, and Just Rhonda. Purveyor of fine memes and purveyor of fine emojis, all in the house. And my friends, thank you for joining us. Thanks for liking the video on your way out. Thanks for sharing the show with a friend or family member, inviting them to come over and join us tomorrow. And of course, returning yourself. I will miss you until we're back here. But we'll pause for the evening. We'll come back tomorrow to get into it again. And of course, in order to do this appropriately, we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
My beautiful friends, now it's that time where the stream must end. You brought the heat with every chat and line. Together we exposed corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. 'cause together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide, fighting for freedom with nothing to hide. Drop a like and don't forget to share, and bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through